I'm going to go across to Swapnil first, and then I'll go across to Harsha. And Mr. Kaushik Gupta also joining us live from Kolkata. Swapnil, to you first. Now, Swapnil, we've had this discussion before as well, that this involves a whole gamut of issues. It's not just restricted to, marriages between same genders, but there, as the government, of course, has been pointing out that this is something that the Parliament must decide on, bearing in mind several other issues that go along with this. How do you see this panning out today?
Good morning, Nupur. What I notice here is what's going to happen here is that the Supreme Court is going to definitely come down with a judgment to say that, to the best of my knowledge, and I think that is the way it should be, that gay marriages should be allowed. And as far as the legislative exercises are concerned, say, for example, changes in the Special Marriage Act and the other legislations as well, that is what the Parliament then to go ahead and do that within the parameters laid down by the Supreme Court, or as the fundamental judgment of the Supreme Court, which will be that, say, for example, if it could decriminalize homosexuality at Section 377 of IPC, obviously, if I'm able to cohabit with another gender, the same gender, then I should be allowed to marry the same gender as well. Say, for example, if there was a heterosexual couple that was living in together, what stops them from getting married tomorrow? In fact, that's a good thing that they're solemnizing something which is looked at by the society very, very favorably. So likewise, if there are two men or two women who are cohabiting together, because Section 377 has been decriminalized, what stops them from getting married? It's definitely Article 19(1)(a), which is freedom of expression, Article 21, which is your right to dignity in life, of course, because that is what I want to live with dignity, because I want to marry the person of the same gender. And Article 14, which is the heart of the Constitution here, where equality before the law. So if a heterosexual couple is equal before the law, then what stops, then what stops a homosexual couple from being equal before the law in that sense? Why there has to be a disparity in that sense? So what is going to happen? Basically, the crux, and I'm trying to make it as simple for your viewers, is that the Special Marriage Act has got certain sections which uses phrases like man, woman, husband, wife. So the petitioners have tried to say that these words should include man, woman, wife, husband, especially wife and husband, should include spouses, or should we say individuals of the same gender as well. So in that sense, you read them into that. Alternatively, you say that some of the sections of the Constitution, some of the sections of the Special Marriage Act are unconstitutional, in the sense that, they say, for example, the notices and objections. Like, one of the things under the Special Marriage Act is that you give a notice first that you want to get married. Then if there is anybody who has an objection, they'll object to that. And if the objection, and that will be determined by the authority, concerned authority, who will say that your objection is bogus, and then he'll go ahead and solemnize the marriage. Now, that was only between a man and a woman. So now what the petitioners are asking is that this notice is an objection. I may not want to publicize whether I'm going to get married or to the person of the same gender. So that in itself is arbitrary and unconstitutional. So that is one way of looking at it. That is something which the court may or may not do, but it may alternatively read into that and say that, yes, let that be the same people also included in the concept of husband and wife. And then following that, there are several aspects to other laws which may then, just as your, the person who pointed out, Nikita pointed out, that, insurance policies, this, that, and the other, all of those things can then be eventually directed to include that this is the fundamental judgment which we are passing today, with certain directions to the legislature. They may not, to say that, okay, let the legislature do this from this forth, and, let me just send back the petitioners saying, is going to be something which I don't think that the Supreme Court of 5-judge Constitution bench will shy away from, and it shouldn't, because it's very important that this is, and to say that it is going to disrupt the cultural ethos, which is the argument of the respondents, because we are a different culture, all of those things, is absolutely bogus. It's a sham argument, because the United States has also,
so Swapnil, you essentially
Hodges has done that. It has said that it is equal, the couples are equal within the Equal Protection Clause of the Constitution.